Thank you so much for watching this first ever elimination round of the International Mock Trial League. It's our 9th tournament, and we're happy to offer a zero-cost, entirely virtual international mock trial contest, student-written cases, because we think that all rise should apply to all of us. Very excited to announce this judging panel for this elimination round between two of the teams who placed in the top 4 of a 40-team competition. Let's go around this list, starting with Judge Andrew Thompson. Please introduce yourself.
Hello, my name is Andrew Thompson. I am a civil defense attorney. I've done mock trial at all levels for over 10 years, and I've coached at the collegiate and middle school level. I love witnesses with a lot of personality and lots of objections.
Thank you very much, Judge Thompson. Judge Margaret Henderson.
Hi, my name is Margaret. I'm a college mock trialer. I would just like to say good luck and fully commit to the bit. I love objections too. I love accents. I love people being confident. So, just show me that you know your stuff.
Next is Judge Jay Odom.
Hello, everyone. My name is Jay. I'm a current senior at Penn State. I've been doing mock trial here for 4 years, and then I did mock trial and in high school as well. I'm very excited to be here.
Judge William Wu.
Hey guys, my name is William. I'm a college competitor. I did mock trial in high school, judged a couple of IMTs. Excited to be here. I just want to say have fun, relax, be confident, and enjoy the round.
Judge Stella Lopresti-Busick.
Hi, everybody. My name is Stella. I am a competitor in AMPTA, that's college mock trial. So I'm one of our A-team captains over at the University of California, San Diego. I've been doing mock trial for 7 years, and I do both attorneying and witnessing. And like many of my co-judges, I just urge you all to be super confident and have some fun.
Last but not least, our presider, Judge Miles Rorta.
Hi there, everyone. My name is Miles Rorta. I'm a current competitor in the American Mock Trial Association. I compete for UC Santa Barbara's team. Most recently, we competed at the Great American Mock Trial Invitational in Washington, D.C. I absolutely love high energy during rounds. A lot of emotion, a lot of energy during statements, during witnesses, directs, all of that. Be confident, have fun, and, be yourselves.
Best of luck to both teams. I'll ask that everybody except our presiding judge and lead counsel for both sides turn off their cameras now. Take it away. The floor is yours.
All right. Let's call the case of State of Tilly versus Jimmie Tanks. My name is Judge Miles Rorta. You can call me Judge Miles, Judge Rorta, whatever works. Now, I've got some preemptive stuff to read over. All scoring judges should have their screen off and audio off until the end of trial. I myself will have my screen off during statements to allow for a better recording. All judges should have video set to hide non-video participants, and making sure to leave their comments and scores on their ballot throughout the trial. Whoever is keeping time for this trial, there should be a volunteer from both sides. Please identify yourselves.
I will be keeping time for the prosecution.
Excellent.
Your Honor, considering we're a little short-staffed today, we'll be juggling time around.
That's totally fine, as long as there's somebody keeping time and who is available to interject if somebody goes overtime. That should be fine.
Yes, Your Honor.
All right. Both sides have 4 minutes for opening statements, 18 minutes to share between 2 direct examinations, 16 minutes to share between 2 cross-examinations, and 6 minutes each for closing arguments. Make sure that time stops during objections. And with that, can the attorneys please make appearances?
Good morning, Your Honor. My name is Sailee Charlu, and today, along with my co-counsel, Christiana Garcia.
Hello, Your Honor.
We'll be representing the prosecution in this case. After the defense has made their introductions, we do have some preliminary matters that we'd like to discuss.
Wonderful. Defense?
Yes, Your Honor. Good morning, Your Honor. My name is Vivian May, and I, alongside my co-counsel, Ms. Anya Luo,
Good morning, Your Honor.
Good morning.
and the defendant, Ms. Jimmie Tanks, in this case.
All right. Prosecution, your preliminary matters?
Yes, Your Honor. First, we'd just like to invoke Midland's Rules 615 and 603, constructively swearing in and sequestering all witnesses except party representatives.
Understood. Any objections to Rules 603 and 615?
No, Your Honor. We'd simply like to designate Ms. Jimmie Tanks as our party representative.
Understood. Prosecution, do you have a party representative?
No, Your Honor.
Understood.
And second, we'd just like to clarify Your Honor's preferences for screen sharing. Should we request to screen share documents or simply state for the record that we're screen sharing?
You can simply state for the record that you need to screen share something, no need to ask permission.
And with that, the prosecution is ready to proceed to opening statements.
All right. Anything from the defense?
Yes, Your Honor. We'd like to inquire about your preferences on striking from the record. After an objection is sustained, would you like us to move to strike or assume that it's stricken?
Do not assume that anything has been stricken after an objection. If something is sustained, please motion to strike.
Yes, Your Honor. And with that, the defense is ready to proceed to opening statements.
All right, thank you. Prosecution, you may proceed with your opening statement whenever you're ready.
Yes, Your Honor. Can I confirm you can see me and hear me okay?
Audio and video seems good to me.
Excellent. The defendant's fury fueled the fire. It's a hot summer night. And it's the night the defendant, Jimmie Tanks, is gonna get revenge on her lifelong enemy, a woman named Bertie Darrow. Today, you'll learn this defendant went to Miss Darrow's house in the middle of the night with no eyes near and no remorse, as she took a tank of gasoline in one hand and a lighter in the other. And she set that house on fire. Today, you'll learn why the defendant was furious, why she started that fire. Members of the jury, today you'll see that just 3 years before the defendant started that fire, she had a shot at a great future, but instead went to jail after Miss Darrow told the police that she stole some cash. That's why the defendant was furious. That's why she wanted revenge, and on July 1st, 2024, she got it. And as the state, that's why we charged the defendant with first-degree arson and first-degree attempted murder. And as the state, we came into this courtroom with a burden. And while it's a high burden, it's not impossible to meet. And that's why we'll meet it by focusing on two facts: the defendant's fury and the fuel. First, the defendant's fury. A jail guard from the defendant's time in jail will tell you that the defendant threatened to do whatever it took to make sure Bertie Darrow suffered. And she'll also show you a picture. Now, folks, when you see this picture, I want you to take a close look at the dates. July 1st, 2000, ? The same day Miss Darrow's house burned down. Members of the jury, that's not a coincidence, it's premeditated. And the second thing is the fire. That premeditated fire. Because a fire investigator will tell you that this fire wasn't an accident. No, it was started by none other than, drum roll please, gasoline. He'll also show you that the defendant had gasoline just weeks before the crime. And the gasoline found in the defendant's possession and the gasoline found at Miss Bertie Darrow's house, well, it had the same identical chemical match. Today, we're not going to show you any eyewitness testimony of them saying Miss Jimmie Tanks burned down their house. And we're not going to show you Miss Bertie Darrow today. She's not going to take the stand. That's okay, because we're going to show you other types of evidence. The gasoline, the quotes, the timeline. And all that evidence points to the defendant's fury fueling the fire. And today, this defendant, when he was furious, well, he didn't turn the other cheek, no. He turned Miss Darrow's house into a campfire. And that's why, as members of this jury, we're going to ask you to be fueled by the commitment to deliver justice. And true justice means holding him accountable. Find this defendant guilty because his fury fueled the fire. Thank you.
Thank you. Defense, you may proceed with your opening statement whenever you're ready.
Yes, Your Honor. May it please the court. She was framed with blame. Members of the jury, you just heard a story about Bertie Darrow, a woman whose life was ruined when my client, Jimmie Tanks, burned her house to ashes. But that story is wrong, because you didn't hear about the mountain of debt that she found herself stuck in, or the insurance claim that she took out exactly a month beforehand. You won't hear any eyewitness testimony or forensic evidence because they won't have any. In fact, the prosecution didn't even have a suspect. Not until Bertie Darrow pointed her fingers at my client, Jimmie Tanks. Now, Miss Garcia kept saying that her fury fueled the fire. But the truth is, Bertie Darrow's debt fueled the flames. Today, the prosecution has charged my client, Jimmie Tanks, with first-degree arson and attempted first-degree murder. And thus, they have to prove that Miss Tanks willingly set that fire to kill Miss Darrow and caused her serious bodily injury. And by stepping into this courtroom today, they took upon the highest burden of proof in our legal system. The burden to prove beyond any reasonable doubt that it was indeed Miss Tanks that committed these crimes. They won't be able to do that today because of the three facts that we will show you: the flame, the fraud, and the frame. First, the flame. You'll hear from Mr. Parks today on stand that Bertie Darrow bought a little bit of paint and 2 huge cans of paint thinner. Members of the jury, you don't need that much paint thinner for that little of paint. The expert reports of both Dr. Harley Blaze and Reynolds will reveal that the cause of the fire was arson. Miss Reynolds will further that the arson was caused by paint thinner. And the second, the fraud. You'll learn today that Mr. Darrow found himself stuck neck deep in debt. He was gambling and had over $200,000 of debt to be paid off. So, when Darrow received the news that he'd inherited his great-aunt's house, he formed a plan. Mr. Darrow was going to get that insurance money of that house to make some quick cash. Now, finally, the frame. With a scheme so large, Bertie Darrow knew that he would be investigated. And thus, he pointed his fingers at my client, Jimmie Tanks. Miss Tanks was Darrow's high school bully who'd just gotten out of jail. The perfect candidate to set up. She was framed with blame. Members of the jury, at the end of today's trial, my co-counsel, Ms. Anya Luo, will stand before you and ask you to find Ms. Tanks not guilty of arson and attempted murder. Because throughout this trial, members of the jury, I challenge you to find any single piece of concrete physical evidence that links Ms. Tanks to the scene of the crime. And you'll find that there is none. Find her not guilty.
All right, thank you. Before prosecution calls its first witness, I would just ask everybody to please switch to gallery view so that everyone can see attorneys and witnesses at the same time. Once that's done, though, prosecution, you may call your first witness.
Yes, Your Honor, we call Dr. Harley Blaze to the stand. Good morning, Dr. Blaze. Could you please introduce yourself to the members of the jury?
Good morning. My name is Dr. Harley Blaze.
And doctor, what do you do for a living?
I serve as the lead fire marshal here in Tilly.
And what qualifies yourself for this position?
Well, as you can see, I possess a doctoral degree in chemistry. I've also attained several certifications from the National Association of Fire Investigators and have, in fact, been working this job for over a decade now.
And so now that we know your background, why are you here in court today?
I was called to the scene of a fire on July 1st, 2024. You see, Bertie Darrow's house had been burned down. I was called to conduct an investigation of the property and discover whether the fire was intentionally or accidentally set.
And what materials have you reviewed?
In order to properly investigate this case, I reviewed the materials of exhibits 1, 2, 6, 7, and 9, as well as the other 5 witness statements in this case.
Your Honor, will now be screen sharing a demonstrative. Now, Dr. Blaze, how did you conduct this investigation?
I used what's known as the triple P method. It stands for the patterns, the pockets, and the presence.
And did you reliably apply the triple P method to the facts of this case?
Certainly. This method is standard in my field. In fact, I learned it from the National Association of Fire Investigators. It's been extensively peer-reviewed, and we use it for all arson investigations.
And so if we're looking at that first P, what does patterns mean?
Well, when I initially arrived on the scene of the fire, I noticed that the fire had been controlled and mostly put out. However, the damage was already extensive. Bertie Darrow had suffered a long, severe burn to her right arm, and the house itself was surrounded in unusual burn patterns.
Doctor, could you explain what you mean by unusual burn patterns?
Certainly. In this case, I observed what's called puddle-shaped burn marks.
And can you tell the members of the jury why puddle-shaped burn marks are particularly significant?
403 as to misleading, this demonstrative specifically. May I be heard?
Yes, please.
Your Honor, the house that's depicted in this exhibit is nowhere near what Bertie Darrow's home actually looks like. And the dashed lines that they're using to symbolize the pour patterns, they also don't show what those burn patterns would look like, and putting it next to the text unusual burn patterns can be misleading or confusing to the members of the jury.
Prosecution, do you have a response?
Yes, Your Honor. Under 2 things. 1, the bar for 403 is very high, and it has to be very misleading to the jury in order for this exhibit or this visual demonstrative to be omitted. Second, we're just providing a visual for our members of the jury to simplify the complex process of the method that Dr. Glaze went through when he was considering his analysis and his conclusion. Thus, 403 does not apply to this demonstrative at all.
Your Honor, if I may.
Yes.
Your Honor, while we do agree it is a high bar, Your Honor, if you look at these dashed lines that seem to show the burn patterns, they seem to be going all around the house and at the similar intervals, but that's not necessarily what the crime scene actually looked like that night. The burn patterns might not have necessarily gone all the way around the house. There could have been varying different sizes. It's still misleading to the jury.
Your Honor, quick response?
I don't think that's necessary. I think I'm ready to make my ruling. I understand the objection, but I think in this instance, because I don't personally know what the house actually looks like or what these burn patterns are, I can't say whether or not they're similar. But I think the cartoon house and the dashed lines, I don't think it's really suggesting anything about when anything could have happened or where these burn patterns were or what they looked like. I think it's just a pretty simple demonstration. And I do agree that the bar for something being more prejudicial than probative is extremely high. So I'm going to overrule it this time.
Yes, Your Honor.
Dr. Glaze, I'm just going to re-ask my question. Can you tell the members of the jury why puddle-shaped burn marks are significant?
Certainly. Puddle-shaped burn marks are almost always caused by pools of ignitable liquid. Now, this obviously indicates arson because ignitable liquid isn't usually left near a house for no reason.
Now, what about that second P, the pockets?
Specifically, I found gaps in the walls of a house caused by ignitable liquid. You see, in ordinary fires, the walls just look charred. They're evenly burned. But in this case, the wall was more burned near the seams, again, indicating ignitable liquids used to accelerate the flames.
And what does that mean?
Well, based on this evidence, it was clear to me that the fire had been set using some kind of flammable liquid to make the fire spread fast.
And can you tell us about that third and final P, the present?
Yes, I collected fire debris from areas I suspected to be pore patterns, places where flammable liquid was most likely spread. Now, generally, this was where the fire had managed to burn through the concrete.
And how did you analyze those specific samples?
I used a testing method known as a gas chromatography mass spectrometry test. It's basically a way of identifying ignitable liquids.
Dr. Glaze, could you explain your findings?
Actually, I have a quick demonstration for the gas chromatography mass spectrometry test.
We'll continue, Doctor.
Well, as you can see here, this is a mixture of metal and sand, the same way that fire debris are a mixture of ignitable liquids and fire debris. Now, these two substances aren't individually able to be distinguished because they're mixed together, like this. But when you use a gas chromatography test, it allows you to separate the two, like how this magnet allows me to separate the metal from the sand.
And so if we're looking at this visual demo right here, what do these results show?
Well, these results were, if they were ignitable liquids and a fire debris, would show that ignitable liquids were in fact present in the substance, and I can use a mass spectrometry test to compare this ignitable substance to all the other ones in a database to tell what it is precisely.
And Doctor, what specific ignitable liquid did you find?
In this case, the test revealed gasoline in all three samples to a near 100% degree of scientific certainty.
Was there any other sign of the substance being gasoline as well?
There was. On a tip from Bertie Darrow, I went to go investigate Jimmie Tanks as a potential suspect.
And what did you see Jimmie Tanks doing?
Well, when I arrived at the Tanks residence, I observed Jimmie pouring out a substance from a red plastic container into a blue hazardous waste drum. This was all I needed to conclude probable cause, so I arrested him.
And what was the substance that you found in those containers?
It was confirmed by a lab analysis to be gasoline, the same substance that the GCMS test confirmed to have accelerated the fire on the Darrow property.
Now, based on your analysis, what's the conclusion about the cause of the fire?
My conclusion about the cause of this particular fire was that the fire was set and sped up using gasoline, and that gasoline is the substance that Jimmie Tanks was caught disposing of.
Thank you, Your Honor. No further questions.
Thank you. Cross-examination whenever you're ready.
Yes, Your Honor. Good morning, Dr. Blaze.
Good morning, ma'am.
I want to begin with your investigation the night of the fire. After you arrived on scene that night, you saw forensic signs that pointed to arson?
I did.
And you spoke to Bertie Darrow?
I did.
He talked about a shadowy figure?
That's correct.
And Darrow was confident it was Jimmie Tanks, right?
Yes, they said that he was always out to get them.
But after hearing this, you didn't ask him about any other potential suspects?
No, at the moment there were none.
You didn't speak to any neighbors about what they might have saw?
No.
Instead, you only took Bertie Darrow's word.
That's right. I traveled over to the Tanks residence to immediately investigate.
And after you traveled to her house, you saw Miss Tanks pouring liquid into the container?
Yes.
You didn't stop to see what she might do with that liquid?
No.
Because, Doctor, in your own words, that was all the confirmation you needed.
That's correct. I concluded probable cause and arrested him.
Now, Dr. Blaze, I want to shift gears and talk about the fire you investigated. You collected 3 samples from the house that night?
Yes.
And all 3 were from areas on the ground you suspected were pour patterns?
That's correct. And by identifying ignitable liquids in them, we confirmed that they were.
And looking at those pour patterns, you found there was gasoline, right?
That's correct.
But you only took samples of the ground?
That's correct.
You didn't take any of the walls?
I did not.
So if there were any other ignitable liquids on the walls, you wouldn't be able to tell us that, right?
My colleague, M. Reynolds, conducted an investigation of the property. They collected samples of the walls to conduct a GCMS test, if that's what you mean.
Dr. Blaze, bringing you back to my question, a yes or no. If there were any other ignitable liquids on the walls, you wouldn't be able to tell us that.
No, I would be able to.
And now, Dr. Blaze, you talked a lot about gasoline today, but I want to talk a little bit more about what you don't have. Dr. Blaze, there wasn't any security footage of the crime taking place that night?
There was some footage of a shadowy figure pouring out or carrying 2 containers. Obviously, it was clearly inconclusive, and I didn't allow it to affect my conclusion that much.
All right, that footage, the person who was carrying those containers wasn't clear?
It wasn't. It was a very indistinct footage, like I said.
And there were no fingerprints of Jimmie Tanks found at the house?
Certainly not. It was a fire.
There were no eyewitnesses tying her to the crime?
Bertie Darrow claimed to have observed Jimmie Tanks, but no.
So in other words, you were not able to find a single piece of concrete physical evidence that put Miss Tanks at the scene of the crime that night?
No, I was.
Objection, Your Honor. 4-3 misleading. May I explain?
Yes, please do.
Your Honor, under stipulation 5, it states that Harley Blaze had probable cause to arrest Jimmie Tanks on that night. And so the defense attorney is talking and questioning Harley Blaze about his methods and whether he did have probable cause or not to arrest Jimmie Tanks. However, this is misleading for our members of the jury because according to stipulation 5, that has already been established.
Defense, do you have a response?
Your Honor, as you ruled previously, to be misleading must be a very high bar. And Your Honor, right now this line of questioning isn't questioning whether or not Dr. Blaze had probable cause to arrest Jimmie Tanks that night. We agree that the facts and evidence seem to point towards Jimmie Tanks. But right now what this line of questioning is pursuing is that after he made the arrest and after there was more evidence that came into light, whether there was anything actually physical, like security camera or fingerprints, to put Miss Tanks at the scene of the crime that night.
Response, prosecution?
Yes, Your Honor, we believe we have met that high bar and at 4-3 in this instance. Because by asking about the fingerprints or the security cameras, they're still questioning whether Harley Blaze had probable cause to arrest Jimmie Tanks on that night. Thus, we ask that under 4-3, this be omitted.
Can I be reminded whether or not the specific pieces of evidence, that security camera footage and the lack of other evidence, was this collected after the arrest or before?
Your Honor, the security camera footage was collected afterwards, and as for the fingerprints, this is speaking about what Dr. Blaze doesn't have.
Okay. I think that I'm going to rule similarly to my previous ruling on 403. I'm going to overrule it this time. I believe that this is not substantially more prejudicial than it is probative. I think that although the stipulation does state that Harley Blaze had probable cause, I think that this is simply examining the witness's credibility and to what extent that probable cause is. I don't think it's outright disputing that the cause was probable. It's just going into the finer details, which I think is okay at this time. Prosecution, if you believe this goes too far in the future, feel free to re-raise, but at this moment, I will overrule.
So, Dr. Blaze, I'll re-ask my question. A yes or no, you were not able to find a single piece of physical evidence that put Miss Tanks at the scene of the crime that night?
No.
Thank you. Nothing further, Your Honor.
Thank you, counsel. Will there be any redirect for this witness?
Yes, Your Honor. Now, Dr. Blaze, how did you eliminate alternative suspects?
Well, I read the other witness statements, and in M. Reynolds' statement, they took note of paint thinner on the walls of Bertie Darrow's residence and took that as reasonable cause to conclude that the potential arsonist may have been Darrow. However, I eliminated this theory because I know that Darrow had repainted their house earlier in the day, which means that paint thinner would reasonably continue to be on the walls even after the time of the fire. However, gasoline was found to an equal degree of scientific certainty and has no reasonable explanation for being on the property unless it was there for arson and used by Jimmie Tanks, who had possession of it.
Thank you, Your Honor. No further questions.
Thank you. Recross?
No recross, Your Honor.
All right. Thank you. This witness may be excused. Prosecution, whenever you're ready, you may call your next witness.
Yes, Your Honor. We call Billy Huxley to the stand.
Howdy, everybody. Oh, seems like I've still got my hair roller in. My apologies.
No worries, ma'am. Hello, ma'am. Can you introduce yourself?
Name's Billy Huxley. What can I say? My papa and mama were expecting a cowboy and not a cowgirl.
Where are you from?
Greensburg, Kentucky. Round them parts, I was raised more southern than a chicken fried steak with a side of grits.
Ma'am, what do you do for a living?
Oh, me? I've had more 9-to-5s than Dolly Parton herself. There's me with her over there. But now I'm working down at the Steel Bar Saloon, better known as the Willow County Jail.
What's your position down at the Steel Bar Saloon?
Jail guard. I keep this here eye on all the jailbirds.
Have you ever monitored an inmate named Jimmie Tanks?
Yes, ma'am. I monitored Tanks for roughly a year, starting in 2021.
Now, ma'am, are you aware of what the defendant is being accused of today?
Yes, ma'am. These here court folks believe that Jimmie Tanks tried to kill somebody with fire.
Let's see if the defendant displayed any signs of fury while in jail. Walk us through the first time you saw the defendant in jail.
The first time was the 9th of March, 2021. I saw Tanks just standing in the dirt yard one morning, and I was shook. I knew Tanks before she was wearing that orange jumpsuit. I couldn't help myself from going up to her and asking why she was in the clinker.
How did she respond?
Oh, Tanks, she looked surprised to see me. She rolled her eyes and took a big gulp before telling me she wasn't the good kid everyone thought she was.
Ma'am, after the defendant said she wasn't the good kid everyone thought she was, did she explain why she said that?
Well, she ended up fessing up to snatching some cash from a shop downtown. She wasn't as slick as she thought she was and ended up getting arrested.
To your knowledge, who turned her in?
Tanks told me it was somebody named Bertie Darrow. They knew each other from school, and I reckon Darrow caught Miss Tanks red-handed and turned her in.
What happened next?
Well, I told them they had it coming for stealing, and I reckon Tanks didn't take too kindly to my words. Her face puffed up redder than a tomato, and her fist balled up.
Hold up. So after the defendant's face turned red and her fist balled up, did she say anything else?
Tanks absolutely screeched, "Trust me, one day I'll show Darrow what true fire looks like. And I'll do whatever it takes to make sure Bertie Darrow suffers."
Ma'am, did she say why she wanted Miss Darrow to suffer?
Well, ma'am, she quite literally said, "Darrow destroyed my life. I wouldn't be here if not for that rat."
Stating for the record, we're going to go ahead and display a timeline of events for the members of the jury. Ma'am, let's talk about the type of company the defendant kept while in jail. Did you see the defendant hang around with a specific person?
I believe you are muted.
Hello? Can you hear me and see me okay?
Sorry, not the attorney, the witness. You're both
My
unmuted now.
apologies. I'm not very good with this new technology. My grandkids normally tell me how to do these things.
No worries, ma'am. All right, ma'am. So when you would see the defendant in jail, did you ever see them hanging around with a specific person?
I did, ma'am. In March, you betcha, I started seeing Jimmie Tanks hanging out with a fella named Alex Leonard. They were thick as thieves, yapping, sitting at the table, playing cards, that kind of thing.
At this time, we bring the court's attention to Stipulation 12. Alex Leonard was convicted and sentenced to 40 years in prison for malicious arson. When the defendant and the arsonist were together, did you hear them say anything odd?
Yes, ma'am. It was on the 16th. It was free time, and I spotted Tanks and Leonard together in the rec room. And Leonard started rattling off what sounded a bit like instructions to Tanks.
What do you mean instructions?
Well, to quote Leonard, Tanks would need to know where the target lived and needed time to pour the good stuff around the place when it's dark to ensure things go as planned.
Could you repeat that? You cut out briefly.
Yes, Your Honor. Objection as to hearsay.
Understood. Could you elaborate?
Yes, Your Honor. The statements made by the arsonist Alex Leonard are here used for the truth of the matter asserted.
All right. Prosecution, why is this not hearsay?
Your Honor, we're not offering this statement for the truth of the matter asserted, which under 802, if we look back at hearsay, doesn't actually qualify as definitionally hearsay. Rather, it goes to the knowledge. This is how the defendant knew what to do, how to commit arson. All we care about is the defendant's knowledge and the subsequent action thereafter.
I'm interested to hear about that exception hearsay. What do you mean that this does not fall under the definition of hearsay?
Your Honor, we're not offering these statements for the truth of the matter asserted.
Okay, that's what you mean. All right.
Yes, Your
Defense, what is your response to those?
Your Honor, these statements are clearly being offered for the truth of the matter asserted. The witness just testified that Alex Leonard was essentially teaching Ms. Tanks how to set a fire. If this is not being offered for the truth of the matter asserted, Your Honor, then we don't see the relevance in this statement coming in.
Your Honor, can I make an offer of proof?
Yes, please.
Your Honor, we're offering these statements to show the subsequent action, aka the knowledge of the defendant. Alex Leonard, the arsonist, was telling Tanks that he would need to know where the target lived, pour the good stuff. Your Honor, surely we don't actually think this person was telling the defendant how to commit arson, but rather we're bringing this in to show that the defendant had the knowledge, okay, this is how I might commit arson in the future.
Are you contesting that this knowledge was not, in fact, used by the defendant to know how to commit arson? Because that's what it sounds like.
Well, Your Honor, it goes to his knowledge, so it wouldn't necessarily be that in that moment Tanks would be going and committing arson, but it goes to his knowledge that he knew these things.
Okay. Defense, do you have a response to that?
Yes, Your Honor, we'd be happy with limiting instruction on these statements that they're not taken for their truth value.
Okay. In that case, I will let this in with limiting instruction that these statements not be taken for the truth of the matter. However, prosecution, please do not stray too far into the area in which you are contesting that these statements are, in fact, about how to commit arson, how to do that properly, and whether or not the defendant would have that knowledge. So please keep this line of testimony concise.
Certainly, Your Honor. Now, ma'am, can you repeat what those instructions were?
Yes, ma'am. To quote Leonard, he said Tanks would need to know where the target lived and needed time to pour the good stuff around the place when it's dark to ensure things go as planned.
What was the defendant doing at this time?
Gosh, now that I'm thinking about it, Tanks even said something along the lines of they would look into paint thinner or gasoline when the time was right, while they were shaking their head.
Your Honor,
Let's see.
Can you repeat yourself?
Yes, Your Honor, at this time I re-raise my objection as to hearsay.
Hearsay regarding which statements?
Regarding the statements that this witness just testified on, opposing counsel moments ago just told us that these statements weren't instructions, and now Ms. Billy Huxley has just testified that these statements, which sound like instructions, are for Tanks to set a fire.
Defense, do you have a response? Or prosecution, do you have a response?
Yes, Your Honor. This goes to the subsequent action of the defendant. She heard these statements, so then she responded with, I'll look into gasoline. Your Honor, that is most certainly a subsequent action, and under Rule 802 doesn't qualify as hearsay.
Defense, do you have a final response?
Yes, Your Honor. At this time, this convicted arsonist, Alex Leonard, is giving Ms. Tanks instructions on how to set a fire, as this witness just testified.
Okay, I think that I'm now going to overrule. I think that because this has now gone into what the defendant directly said afterwards and how that ties into a potential subsequent action afterwards, this now does qualify under subsequent action. I wasn't quite as sure before, but now that we have further testimony regarding the actions that the defendant is going to take and what they said to this convicted arsonist, I think that it does qualify. So I'm going to overrule.
Yes, Your Honor.
Ma'am, let's see if the defendant mentioned fire again. And when was the next time you saw the defendant?
Well, the last time I saw Jimmie Tanks was May 13th, 2021. I was tasked with monitoring Tanks' therapy group sessions with Miss Karen Garcia, the therapist.
All right, and what happened during this therapy session?
Well, Miss Garcia, she always gave these notebooks to the inmates, saying something about drawing their feelings, and she'd have them draw in those notebooks.
What did the defendant do after the therapist handed him that notebook?
Oh, well, Tanks was real into it, drawing for a good 40 minutes or so. One time, Tanks left their journal out, so I grabbed it and gave it a good old flip through.
What did you see?
One of them drawings really took me by surprise. Let me tell you, it was a drawing of a 2-story house on fire. I didn't know Tanks had such a good drawing hand.
Ma'am, let's take a closer look at the drawing of the house on fire. Stating for the record, we're going to be screen sharing Exhibit 10. Ma'am, is this the drawing you found in the defendant's notebook?
Oh my eyes are not as good as they used to be. So if y'all give me a moment to get my spectacles, I can take a look at this.
Sure, ma'am.
That's right. That's the exact picture I saw in Jimmie Tanks' notebook that day.
Your Honor, remove to enter Exhibit 10 into evidence.
Any objections to entering Exhibit 10?
Yes, Your Honor, as to hearsay and lack of foundation, may I be heard?
Yes, let's take those one at a time. We'll start with hearsay.
Yes, Your Honor, this is an out-of-court statement as in the drawing made by Ms. Tanks during a therapy session. And as for a lack of foundation, Your Honor, while we know that this drawing was made by Ms. Tanks, we're not sure if the writing on the top or that little signature over there is indeed Ms. Tanks's.
I think I'm going to. What statement do you believe is being presented by this drawing?
Your Honor, we believe that the picture, or more specifically, rather, the text on the top and the little signature at the side is hearsay, although we'd be happy to simply crop out the image and let the jury or let the court see the image and the signature.
Your Honor, may I be heard?
Yes, please.
Your Honor, under Rule 801D2, party opponent, this is admissible. This picture was drawn by the defendant, Jimmie Tanks, as we've agreed in pretrial. Jimmie Tanks is the defense's party representative. Your Honor, this is most certainly admissible.
Your Honor, may I be heard?
I don't think that's necessary on the grounds of hearsay. I don't see any specific statement that is being elicited here. It says JT on the right and then 71202 question mark. I don't believe either of those have any inherent truth value to them. I think that goes to weight, not admissibility. So I'm going to overrule on the hearsay. What do you have to say about the lack of foundation?
Yes, Your Honor. While this witness saw Ms. Tanks draw the image, if we notice closely, this image is done in some sort of marker, and the markings at the top and the signature are done in pen. We're not sure if the signature and the markings at the top are actually from the defendant.
Okay, prosecution, do you have a response on those grounds?
Yes, Your Honor. There has most certainly been sufficient foundation laid on the record that Jimmie Tanks had her notebook, took her pen in one hand, drew the picture, and then left the table. Your Honor, as the witness recalled, there was nobody who went and grabbed that notebook. And Your Honor, if we look at stipulations, all exhibits are true and authentic. There hasn't been altered or changed in any way. And as this witness has already testified, she didn't see anyone mess with it. Hence, the sufficient foundation has been laid that Jimmie Tanks was the one who drew this picture.
Defense will hear one final response.
Yes, Your Honor. While we do agree that Ms. Tanks was the one that drew this image, prosecution counsel cannot provide evidence that says that Ms. Tanks was the one that wrote the markings on the top and signed that picture. Because as we can see, the drawing is in marker and the markings at the top are in pen.
Okay.
Your Honor, may I be heard?
That's not necessary. I think the witness has just testified to having seen this image in the past and that it is true and authentic for the last time they saw it. They didn't mention that these markings on the top or the side were different than they were before. So I think foundation has been laid. I'm going to overrule.
Yes, Your Honor.
And if there are no further objections, then Exhibit 10 will be entered into evidence.
Your Honor, can we display that for the members of the jury now?
Yes, that's fine.
Ma'am, can you describe the drawing?
Oh, goody. Let me get my spectacles back on. Yeah, so you can see here it's a 2-story house with these flames on it. It's on fire. These flames are all bright red and swirling.
All right, and what about the top left corner?
Oh gosh, I'm really gonna have to squint for this one. But at the top, there's some writing. It looks a little bit like dates. One says July 1st, and the year seems unclear. And the other one says February 26th, 2021.
All right, we can take that drawing down. Ma'am, to your knowledge, when did Bertie Darrow's house burn down?
Seems like I won't be needing my spectacles anymore. But I heard on the news that Bertie Darrow's house burned down on July 1st.
Your Honor, and no further questions.
Thank you. Cross-examination whenever you're ready.
Yes, Your Honor. Give me a moment. Your Honor, may I proceed?
Please do.
Yes, Your Honor. Good afternoon, Miss Huxley. I'd like to begin with your job at Aberdeen High School.
Howdy. How you doing?
Hi. You flunked out of the police academy in early 2019, right?
That's right, ma'am. I wouldn't consider myself the sharpest tool in the shed.
And that was because of substance abuse issues, right?
That's right, ma'am.
So you ended up on your cousin's couch.
That's right. My cousin Vinny.
And you decided to apply for jobs so that you wouldn't become your cousin's couch potato, right?
That's right, ma'am. I didn't want to owe anything to Jimmie. He's like a brother to me.
And you got a job as a security guard at Aberdeen High School, right?
Yes, ma'am.
Now, Miss Huxley, during this job, you would go on smoke breaks 2 to 4 times a day?
That's right, ma'am. I'm not proud of my past. I've actually been clean for 4 years now. But that's right.
And you were smoking things other than cigarettes, weren't you?
Yes, ma'am.
Objection. As to character evidence, may I be heard?
Yes.
Your Honor, currently, opposing counsel is exploring this line of questioning as character evidence. Your Honor, if I can proffer.
Please.
Your Honor, they're going to be offering that the fact that this witness used marijuana in the past and that it makes her less credible today in court. Your Honor, that most certainly is character evidence, and it's going to prejudice the jury in a way that isn't admissible.
Defense, where are you going with this line of testimony?
Your Honor, under Rule 404b2, this is not considered character evidence because we're simply using this to show the bias of the character against the defendant. Now, I'm not trying to say that Ms. Huxley here used drugs in the past and will do so in the future, but instead, we're trying to use this evidence to prove the potential bias that she may have against Ms. Tanks for turning her in.
Your Honor, can I be heard?
Yes.
Your Honor, we're most certainly fine with that line of questioning, but Miss Ma going into the specifics of her marijuana usage, she could simply just say drug usage, but the word marijuana is specifically gonna mislead the jury into thinking this person's a crazy drug addict. Your Honor, most certainly none of us want that here today. So if she could refrain from using the word marijuana, we'd be fine with this line of questioning.
I'm not sure if that's entirely necessary. I think that while this is in international jurisdiction, I don't believe that. I think that stating that somebody's previous use of marijuana making them a crazed drug addict is going a little bit far. I think that I don't see this as being referencing a specific trait. Under character evidence, it needs to be a specific trait that is then going to be exhibited further in the future. I don't believe that's what's going on right now. If you believe that this line of testimony goes further into that, feel free to re-raise your objection, but I think for now I'm going to overrule.
Yes, Your Honor.
Ms. Huxley, I'm going to ask my question again. You would often go on smoke breaks, right?
That's right, ma'am.
And in those smoke breaks, you would often smoke things other than cigarettes, right?
That's right, ma'am.
Now, Miss Tanks caught you on one of these smoke breaks, didn't she?
Yes, ma'am, she did.
And when Miss Tanks told the principal, you were fired on the spot, weren't you?
I was.
And Miss Huxley, you were filled with anger because Jimmie had turned you in for smoking weed on campus?
Well, ma'am, I don't know anybody who would be happy about losing their job, so I was not thrilled.
And Miss Huxley, due to that incident, you were facing misdemeanor charges, right?
That's right, ma'am.
Miss Huxley, I'd like to talk about your second job at the county jail. Now, after, you were working at that jail as per the court's order, right?
Yes, ma'am.
And during your time there, you saw Jimmie Tanks there, right?
That's right.
So you decided to go talk to Miss Tanks, right?
Well, wanted to catch up on old relations. I stopped by to say hi.
And you found out that Miss Tanks was in there for theft, right? Didn't you?
That's right, ma'am. That's what she told me.
And in your conversation, Miss Tanks seemed genuinely remorseful, right?
Objection. As to lack of foundation, may I be heard?
Yes.
Your Honor, there has been no foundation laid on the record as to how this witness would know that Miss Tanks felt genuinely remorseful as of how she was acting or how her face looked. There has been no foundation laid on the record, so them asking this witness if she felt remorseful most certainly isn't allowed.
Defense, are you able to lay that foundation?
Yes, Your Honor, we'd be happy to lay that foundation.
Okay, then please do lay that foundation. So, sustained until that foundation is laid.
Motion to strike the previous question.
Pending that foundation, yes, but if that foundation is laid, then that will not be stricken.
Understood.
So, Miss Huxley, let me ask you again. You went to go talk to Miss Tanks in the county jail, right?
My apologies, ma'am. I've been coming down with something nasty. Glad this trial's on Zoom so that everybody stays safe. But that's right. I did talk to her.
And Miss Huxley, in your own words, she seemed genuinely remorseful, correct?
That's right, ma'am. I can't be for sure what she was thinking in her head, but it seemed as if she was remorseful.
And you still decided to tell her that she had it coming?
That's right, ma'am. If you do something, you gotta do your time. That's what I believe.
Now, Miss Huxley, moments ago on direct examination, you mentioned some statements between Miss Tanks and an arsonist. Now, during that conversation, they were whispering, weren't they?
That's right, ma'am.
And as you got closer, they stopped talking, right?
That's right, ma'am. They looked at me as if I was hearing something I shouldn't have heard.
And Miss Huxley, all these statements that you heard them from years ago, right?
That's right, ma'am.
So, Miss Huxley, to get this straight, we're relying on your memory of these statements from years ago?
That's right, ma'am. While I would not consider myself the sharpest tool in the shed, I've got quite good memory.
Now, Miss Huxley, the last time you saw Miss Tanks was over 3 years ago, wasn't it?
That's right, ma'am.
And Miss Huxley, you talked a lot about the prison fire today, but let's see what you don't know, all right?
The prison fire?
Yes.
I don't believe Miss Garcia asked me about that.
There was a prison fire, wasn't there?
That's right, there was.
But there was no... My apologies, Miss Huxley.
Oh, I'm finished. Go ahead.
Miss Huxley, but there was no security camera footage to confirm that prison fire, was there?
Objection.
No, ma'am.
As to lack of foundation, may I be heard?
Yes.
Your Honor, up to this point, this is the first time we've ever heard about a jail fire. Your Honor, we would just ask that some basic facts of this jail fire get laid on the record. That way this witness could have the full story and she can fully expand her answers on cross-examination.
Yes, I would agree. Please lay some more foundation as to what this jail fire was. I don't believe we've heard anything about it up to this point.
Yes, Your Honor.
Your Honor, just for the record, is that sustained?
Yes, that is sustained.
All right, motion to strike.
Again, I don't think entirely necessary. I think all we've heard is that this jail fire exists. I think unless this goes further and no more foundation is laid, then we can strike it. But I think at this point, that's not necessary.
Yes, Your Honor.
Ms. Huxley, there was a jail fire at the jail you were working at on May 6th, correct?
That's right, ma'am, in the lunchroom. Remember it clear as day.
Exactly, in the lunchroom. And in that fire, Miss Tanks and Alex Leonard were there, right?
That's right, ma'am, they were.
All right, and after the fire, you heard Miss Tanks say some things, didn't you?
Yes, ma'am, I did.
But there was no security camera footage, was there?
No, ma'am. I heard Tanks telling Leonard not bad for a trial run.
Objection. As to lack of foundation, may I be heard?
Sure.
Your Honor, there hasn't been any foundation laid on the record as to how this witness would have access to potential security footage, so she would know if it existed or not. We would just ask that it's laid on the record.
Okay, the defense, you have a response?
Yes, Your Honor. Miss Huxley at the time was working as a prison guard at that jail. It's reasonable to assume that she would have access to the security cameras.
Okay, I think that this witness can testify as to their personal knowledge of whether or not there's security camera footage. I think that we could stray away from questions that directly state whether or not there was any at all, and just if this witness is aware of any, but I think I'm going to overrule the objection. I think this is fine so far.
Yes, Your Honor.
So, Miss Huxley, we don't know who started that fire, do we?
My apologies again. The technology gets me every time. No, we don't, ma'am.
And there's absolutely nothing to tie my client to the crime, is there?
No, ma'am.
And in fact, the fire could have been an accident for all you know, right?
That's right, ma'am. We don't know who started the fire.
Thank you, Miss Huxley. No further questions, Your Honor.
Thank you. Will there be any redirect?
Yes, Your Honor.
Whenever you're ready.
Hello, ma'am.
Howdy again.
Now, I just want to pick up where Miss Vivian left off, all right?
Yes, ma'am, of course.
Ma'am, did you ever use drugs in the past?
I did in the past.
Your Honor, at this time, we bring the court's attention to Stipulation 11. Billy Huxley has been regularly tested for narcotics since January of 2021, and all tests have been confirmed negative. Now, ma'am, do you still hold any resentment towards the defendant?
Well, at the time, I was jumping from job to job already. So when I lost my job, let me tell you, it was difficult. I knew it'd take me some time to find another one, and my life really took a turn. But now, I'm actually real glad Jimmie Tanks did that, because it gave me a chance to look into myself and change myself for the better.
Thank you, ma'am. Your Honor, no further questions. May this witness be excused barring recross.
Will there be any recross for this witness?
No, Your Honor.
All right, this witness may be excused.
Good day, everybody. Goodbye.
Take care, Ms. Huxley. With that, we rest our case in chief.
All right, thank you, counsel. With the conclusion of prosecution's case in chief, we will now take a short 5-minute break. Let's have everybody back here at 12:41 Pacific Standard Time, ready to proceed with defense's case in chief. All right, welcome back, everybody. Are both sides here and ready to proceed?
Yes, Your Honor, the defense is present and ready to proceed.
Your Honor, the prosecution is also ready to proceed.
Wonderful. Both sides are here and ready. Defense, you may call your first witness.
Yes, Your Honor, we'd like to call Miss M. Reynolds to the stand. Your Honor, may I proceed?
Yes.
Good morning, ma'am. Could you please introduce yourself to the court?
Good afternoon, ma'am. I'm M. Mackenzie Reynolds.
Miss Reynolds, what do you do for a living?
Well, besides from being a full-time mother, very taxing job, by the way, I'm with the Tilly Insurance Group, and I work as an insurance inspector and investigator. Specifically, I investigate fires in insured buildings to see if the insurance claim is rightful or not.
Now, what qualifies you for that line of work?
I earned my Master's of Science in Fire and Engineering from the University of Michigan. And after I graduated, I joined with the folks over at the police force, where I worked for over 20 years now on investigating fire and arson-related crimes.
Well, ma'am, have you testified in court before?
Yes, ma'am, I have. I've testified as an expert in over 50 cases now. At this point, I should probably just have my own parking spot at the courthouse.
Ma'am, do you know why you're here today?
Yes, I am here to talk about my investigation of the insurance claim in regards to Bertie Darrow's home fire, as well as further investigate whether the fire was set on purpose or was an accident.
And what evidence did you use to conduct your investigation?
I used the evidence I myself collected from the scene of the fire. I also reviewed Dr. Harley Blaze's report, as well as several exhibits. I had also conducted an interview with Bertie Darrow.
And what methods did you use?
Well, I first analyzed Dr. Blaze's report. Then I used a standard method of testing in our field, which is performing the GCMS, or gas chromatography mass spectrometry, on the evidence I collected on site.
Did you use your investigation reliably to a certain degree of scientific certainty in today's case?
Yes, of course, ma'am.
So then, when did you start to investigate this case?
I started in the morning of July 2nd, 2024, around 7 hours after the incident.
And when you arrived at the home, what was your initial report of the premise?
The first thing I noticed about the home happened to be a really visible burn pattern that went from the front porch to the outer walls.
Now, ma'am, you said burn pattern. Could you describe this burn pattern?
Of course. So this specific burn pattern was in a straight line, which is what we call a linear burn pattern.
And what does a linear burn pattern tell you?
Well, a linear burn pattern can be a sign that the ignitable liquid of some sort was used to move or lead the fire throughout the home. So think kind of like a wire or a cable, where the lines connect one area to another, which allows the fire to easily move throughout the area.
Were there any other burn patterns that you found outside?
Yes, there was another burn pattern on the outer wall.
And what kind of burn pattern was this one?
This one was different. It was an area burn pattern.
Would you recognize a picture of this pattern if I showed it to you today in court?
Yes, ma'am, I would.
Your Honor, permission to screen share with what has been marked as Exhibit 6 for witness identification purposes?
No need to ask permission. You can just screen share whenever you need to.
Yes, Your Honor. Co-counsel, if we could get that exhibit up. My apologies, Your Honor, we're having technical difficulties. Thank you, co-counsel.
All good.
Now, Mr. Reynolds, what does this area burn pattern mean?
Well, an area burn pattern is like a puddle. It's large and has no apparent starting point.
and it's often caused either by an ignitable liquid spreading out or if a fire is moving very rapidly.
Now, did you investigate inside the house?
Yes, ma'am. I went inside Darrow's house and I saw a lot of burn marks there as well.
Could you elaborate on the burn marks inside the home?
Well, the burn marks were consistent with the outside, and from looking
Objection,
at
Your
them,
Honor? Under two things may be heard.
Yes, please.
Your Honor, we agree that they are laying foundation, but at this point, the Exhibit 6 must be entered in order for them to continue. Second, under 702C, this testimony is not a product of reliable principles and methods because we haven't yet heard the specific methods of M. Reynolds currently. So we need them to lay that 702C and fulfill that singular prong in order for them to continue, as well as move its exhibit into evidence.
Do you believe that the 702 objection is necessary for this exhibit to be entered, as well as that just it needs to be entered in general, or is the 702 objection separate?
Your Honor, those are two separate objections at this point.
Okay. I would agree that this exhibit does need to be entered before further testimony is laid regarding this. Are you prepared to enter this exhibit, defense?
Yes, Your Honor. May we enter
All
this?
right. Any objections to the entering of Exhibit 6?
No, Your Honor.
Okay. Exhibit 6 is entered. Now, regarding that 702 objection to 702C, defense, what is your response?
Your Honor, I believe Dr. or Ms. Reynolds here has already laid the foundation that she is a qualified expert to testify on these grounds.
What is your response specifically to Rule 702C that the testimony is based on reliable facts and data and methods?
Your Honor, Ms. Reynolds here has just explained her methods. If you would like her to restate the methods that she used, we'd be happy to.
All right, prosecution, what's your response on those grounds?
Yes, Your Honor. If the defense could lay that specific method that M. Reynolds approached when she's reaching her conclusions, that would be great.
Yes, I believe that I did hear some mention of a method being applied, but if you could lay the foundation as to what exactly that method is, that would be good.
Yes, Your Honor. So, Ms. Reynolds, what methods did you use when testing this burn pattern?
Well, I did use the GCMS, or gas chromatography mass spectrometry, and I conducted it on 3 samples of evidence that I collected on site from Bertie Darrow's house.
And what does this tell you?
And the GCMS told me that the burn marks, or the samples that I collected.
Objection again?
Can you explain?
Your Honor, this is under 702B. The testimony is based on insufficient facts or data. May I explain?
Yes, please.
Your Honor, because Dr. Reynolds actually stated in direct examination that she arrived 7 hours after the scene of the crime, the evidence could have been altered or destroyed. Before she arrived, there were firefighters who had tainted the evidence that Dr. Reynolds is currently using in that mass spectrometry test for her analysis and her analysis in general. Thus, the data is insufficient.
Defense, do you have a response on those grounds?
Your Honor, if we may, we could ask Ms. Reynolds her grounds for her investigation, if that would be simpler for the court.
I don't think this is going too terribly far against 702B. If you can lay some additional foundation, that would be fine. So please do that. But at this time, I am going to overrule the objection. But please lay a little bit more foundation.
Yes, Your Honor. Co-counsel, let's get the exhibit down. Now, Ms. Reynolds, I'd like to turn your attention back to when you arrived on scene. When did you arrive?
I arrived 7 hours after the fire had been put out.
Is it possible that within these 7 hours, the evidence on site was altered or changed in any way?
Yes, now that's actually a thing. It's called spoliation of evidence. However, it's highly unlikely that this occurred within the 7 hours that I arrived, since site preservation is a top priority and firefighters are educated on how to keep the site preserved.
So, Ms. Reynolds, do you know how this fire started once you started your investigation?
Right. So, since the fire started from the outside, I've deduced the cause to likely be arson, as that would explain the linear burn pattern as well, since there was a trail that looked like it was deliberately used as a fuse, possibly.
Now, did you use any tests to support that hypothesis?
Yes, ma'am. Now that's the gas chromatography and mass spectrometry I was talking about earlier.
And could you re-explain what these tests do?
Yes. So this is a test that analyzes the substances of each sample. And so by analyzing the 3 different burn samples that I collected, which in this case were the outside linear pattern, outside area pattern, and inside the house, we can figure out if the fire was deliberate or intentional.
And what were the results that you found?
The results showed that the fire was indeed most likely caused by arson, as the outside burn patterns were caused by ignitable fluids, whereas the inside sample was not.
Now, Ms. Reynolds, do you know what these ignitable liquids are?
Right, so I did read Dr. Harley Blaze's report where he found gasoline. However, throughout my investigation, I couldn't find any gasoline or the sort. However, I did find high amounts of paint thinner instead.
Well, is paint thinner flammable?
Very. It can be highly flammable and can easily catch on fire.
I see. So Ms. Blaze, or Ms. Reynolds, based on this on-site evidence, what can you conclude about what happened on that day?
Well, considering all the evidence and tests performed, I can conclude that someone likely set this fire on purpose, and paint thinner could have been used as a medium to spread the fire.
Finally, Ms. Reynolds, I want to talk about Bertie Darrow's financial situation at the time. Are you familiar with that?
Certainly. Now ask away.
Ms. Reynolds, in your investigation, you investigated Darrow's financial situation, right?
Yes, I am an insurance inspector, so I naturally also checked her financial record.
Would you recognize a copy of this financial record if I showed it to you today in court?
Yes, ma'am, I would.
Your Honor, let the record reflect that we're about to share a screen with what has been pre-marked as Exhibit 3 for witness identification purposes. Now, Ms. Reynolds, what's displayed on screen? What is that?
Well, it's a copy of Bertie Darrow's financial record.
And does it seem to be a fair and accurate copy?
Yes, ma'am. Looks like it.
The defense enters Exhibit 3 into evidence.
Any objections to Exhibit 3?
No objections, Your Honor.
All right, Exhibit 3 is entered into evidence.
So, Ms. Reynolds, what can you tell us about this financial situation?
Well, as you can see on screen, Ms. Darrow has $200,000 in mortgage debt, $15,000 in credit card debt, and $10,000 in personal loan debt. And you can also see that Ms. Darrow recently lost $2,000 to gambling.
Thank you. Ms. Reynolds, co-counsel, to get the exhibit down. Now, Ms. Reynolds, are you here on behalf, you're an insurance investigator, right?
That's right, ma'am, for the Chile Insurance Group.
Now, are you here on the behalf of the Chile Insurance Group today?
No, ma'am, I'm here on my own terms, and I was hired by the defense counsel.
All right, Ms. Reynolds, let's move to the insurance policy that Ms. Darrow took out from your insurance group. Your Honor, let the record reflect that the defense is now screen sharing what has been pre-marked as Exhibit 1. Ms. Reynolds, can you tell me what this is?
Yes, ma'am. This is the insurance policy written for Bertie Darrow.
And does it seem to be a fair and accurate copy?
Yes, it seems so.
Your Honor, the defense moves Exhibit 1 into evidence.
I believe we're looking at Exhibit 3 right now.
Oh, my mistake, Your Honor. Co-counsel, if we can get exhibit 1 up and not 3. My apologies, Your Honor. We're having a bit of difficulty.
No worries.
Now, this on screen, what is this?
This is Bertie Darrow's insurance policy.
Fair and accurate?
Yes, ma'am.
Your Honor, at this time, we move to enter exhibit 1 into evidence.
Any objection to exhibit 1?
No objections, Your Honor.
All right, exhibit 1 is entered.
So, Ms. Reynolds, looking at this insurance policy, what can you tell us?
Well, we can tell that in theory, if Darrow's house burned down, the insurance would cover about $925,000.
Thank you, Ms. Reynolds. No further questions, Your Honor.
Thank you. Cross-examination?
Yes, Your Honor.
Whenever you're ready.
Good evening or good afternoon, Dr. Reynolds.
Good afternoon, ma'am.
And so you talked a lot about your inspection methods in your direct. Let's see if that's true. Because you see, Dr. Reynolds, you weren't there on the scene when the crime happened, right?
Right, I got there 7 hours after.
So it's a yes to my question.
That is a yes to your question.
And ma'am, you didn't conduct any evaluations right after the crime, correct?
That's right, since I did start my investigation 7 hours after, but that's a yes.
And in fact, this report was based on evidence provided to you by the defense team, right?
That's right. Though I collected the 3 samples on site, everything else was provided by the defense counsel.
And so you're agreeing with me, right?
That's right, ma'am.
Now, Dr. Reynolds, in your line of work, it's important not to be biased, isn't it?
Absolutely, ma'am. Facts are the priority.
Because bias might get in the way of telling the jury the truth, right?
Absolutely, ma'am. Yes.
Well, let's talk about those alternate theories you just mentioned in the direct. Dr. Reynolds, you mentioned a theory could be paint thinner, correct?
That's right.
But you do know that Bertie Darrow was also repainting their house at that time, right?
Yes, ma'am. I was informed of that.
So you can't actually tell if the paint thinner was used for arson or just for painting, right?
That's right. It is possible it is used for painting or for arson, but that's a yes to your question, ma'am.
Now, doctor, you're not the only expert who analyzed the evidence from the fire scene, are you?
That's right. I analyzed Dr. Blaze's report. Yes.
In fact, the actual forensic testing on the fire debris was conducted by Dr. Harley Blaze, right?
That's exactly right, ma'am.
And Dr. Blaze, after conducting those forensic tests, found clear evidence that gasoline was poured around the house, right?
That's right, ma'am, but only outside the house, since I collected samples from inside the house as well. But that's a yes to your question.
Now, doctor, you did conduct a mass spectrometry test, right?
That's right.
But you collected, like you said 3 times, those samples 7 hours later, right?
That's right. That's also when I got on site.
After the firefighters came?
That's right. The fire had long been put out by then.
After the entire house was hosed down?
That's right. It was cordoned off.
And ma'am, you still can't rule out the possibility that the evidence could have been altered. Isn't that right?
That's right. It is possible that the evidence is altered, though highly unlikely.
Now, doctor, let's talk talk about your compensation. The defense paid you to testify,
That's right.
but you wouldn't agree to testify at your regular rate, correct?
No, ma'am, that's not true.
Ma'am, the defense offered you more than your regular rate, right?
Yes, that's right. $15,000 more.
And you decided to do what the defense attorneys asked, only after they offered you thousands of dollars more. Yes or no?
That's right, ma'am. Since investigating alternative causes of fire does entail higher pay. That's a yes.
Ma'am, you're free to expand and redirect, but are you agreeing with me that only after they offered you thousands of dollars, you decided to do what the defense attorneys asked you to?
Objection, Your Honor, is tasked and answered.
Response, Your Honor?
Yes.
Your Honor, I'm just reaffirming what M. Reynolds says. She didn't give me a clear answer before.
I don't think this is exactly asking an answer, but please keep this brief. Try to keep this to 1 or 2 more questions, please.
Yes,
But
sir.
overruled.
And it's not only you that have money attached to this case. Your company does too, right?
That's right, since my company is the insurance company of Bertie Darrow.
Right. You're employed by an insurance company.
That's right, the Tilly Insurance Group.
And if your company admits that the defendant set the fire, they'll have to pay Bertie Darrow. Yes or no?
That's right, $925,000.
Exactly. Your company will have to pay almost $1 million. Yes or no?
That's a yes to your question, ma'am. That is what the insurance covers.
Thank you. No further questions, Your Honor.
Thank you. Will there be any redirect?
Yes, Your Honor, briefly. Mr. Reynolds, I just have a few quick questions for you and we'll get you on your way, all right?
All right.
Mr. Reynolds, are you here on the behalf of the Chien Insurance Group today?
No, ma'am. I was hired by the defense and I'm here on my own terms.
And how much money would Bertie Darrow lose if, say, or how much money would Bertie Darrow gain if his house burned down?
Well, that would be $925,000, nearly $1 million, since that's covered by the insurance.
Thank you, Ms. Reynolds. No further questions, Your Honor.
Any recross?
No, Your Honor.
All right, this witness may be excused. Defense, whenever you're ready, you may call your next witness.
Yes, Your Honor. Before we call our next witness, maybe we can just get the time discrepancy sorted out so we know how much time we have for this direct.
Yes, I saw that in the chat.
So I'm the P timekeeper, and I worked this out privately with the D timekeeper. And D timekeeper expressed to me that she knew that her app, she was using a specific mock trial app to take her time, and she told me it was having a few issues. So I was hoping we could go with the time I had because I did keep it on a separate one on my phone here. So I actually have it over here. So because she did tell me that she was experiencing technical difficulties. That's all I'm worried about.
If both timekeepers have agreed to that time, I saw it was at 5 minutes and 25 seconds left.
I believe so.
If both timekeepers have agreed to that, then that's perfectly fine by me.
Yu Chao, is that the time you got?
Yes, we have 5 minutes and 25 minutes left. 25 seconds left.
Sounds good then, Your Honor.
All right, you may proceed with the witness direct whenever you're ready.
Yes, Your Honor. At this time, we call Miss Jordan Parks to the stand. Good evening.
Could you? How may I help you? I am so sorry. I pulled an all-nighter last night working down at the shop. I'm awake now.
Well, could you please introduce yourself to the members of the jury?
Hi, my name is Jordan Parks, like Air Jordans and National Parks.
Well, Miss Parks, where are you from?
Well, I grew up in Laguna Beach, California, but then I moved to Little Hamlet for college. Then there was this whole drama about poison, so I moved a few miles away to a more peaceful town, Willow.
And what do you do for a living?
Well, I work at Nuts and Bolts here. It's a small store in Willow.
And how'd you get into this line of work?
Well, I've always been quite a builder. As a little kid, I worked in my dad's garage and drink his coffee. I've even been running a blog of mechanics since I was 13 years old. I got 5 views.
What kind of shop is Nuts and Bolts?
It's a hardware store. We sell everything. You should stop by sometime. We have a 75% off deal on all ladders.
Sounds good, Miss Parks. But how are you involved in today's case?
Well, Jimmie Tanks and Bertie Darrow were both customers I helped out. Jimmie Tanks was actually my first customer ever. I helped her out twice.
Let's begin by talking about your first encounter with Miss Tanks. What was she there for?
Oh, well, that was my first day, June 10th. Jimmie walked in the door and told me she was going for a camping trip on the 4th of July.
And did she buy anything?
Oh, some basic supplies, gasoline for the car, cloth, and of course, an American flag, patriotic stuff.
Afterwards, did you help anyone else?
Well, it was around a week before the 4th of July when I met Bertie Darrow. We were only a couple minutes from closing time when they pulled up.
And what was he looking for?
Oh, paint there. After a while, Bertie finally chose some paint, brushes, a fire extinguisher, and 2 huge cans of paint there.
Is this normal?
Well, I mean, the amount of paint thinner Bertie bought, well, it's excessive regularly. Not to mention, paint thinner is very flammable. It's dangerous.
Objection. Improper opinion under 702. May I be heard?
Please.
Your Honor, there hasn't been any foundation laid that this witness would have enough knowledge to know whether or not the more paint thinner you buy, how or would affect the flammability of it. Your Honor, we haven't heard any foundation that she would know this, and it's an expert conclusion.
Defense, do you have a response?
Yes, Your Honor. We've already heard from Miss Parks previously that she works at Nuts and Bolts, a store that specializes in car parts, mechanics, gasoline's included in that. She helps out customers get what they need. And in previous instances, it doesn't take a specialized expert to tell you that you don't need that much paint thinner for a little bit of paint. Your Honor, that is something she could reasonably do as a lay witness.
Your Honor, may I be heard?
Yes.
Your Honor, the specific answer the witness gave was, the more paint thinner you buy, the more flammable it is. Your Honor, I would fear that's going into expert territory, or whether or not the chemical balance of the paint thinner and how it would get more flammable with the more paint thinner you buy. There hasn't been any foundation laid. We're fine with her simply talking about the flammability of paint thinner, but we'd ask if she would refrain from using the more paint thinner you buy, the more flammable it gets. That's an expert opinion.
Your Honor, if I may be heard.
That's all right. I'm going to overrule. I think that simply stating that the more of a flammable substance there is, the more flammable something could be is not necessarily an expert opinion. I think that's perfectly reasonable for somebody who works around flammable substances to say. If you believe that this goes further, you can re-raise, but I think as it is now, just saying that more paint thinner, which is flammable, makes something more flammable is perfectly admissible.
Yes, Your Honor.
Ms. Parks, considering that paint thinner is flammable, did you warn Darrow?
Well, I told him the safety precautions. He seemed really focused on getting home. He got mad at me because I was scanning too slow or something. It wasn't my fault. It would have been a really
Objection. As to speculation, may I be heard?
Please.
As to the witness's last answer, he seemed really focused on getting home. Your Honor, that is speculation, and there hasn't been any foundation laid as to how this witness would know. She's currently diving into the mindset of Bertie Darrow, which is textbook definition speculation.
Defense, are you able to offer any foundation as to how this witness knows that that Tanks was focused on getting home, or Darrow's, whichever the witness was?
Your Honor, we can just strike the witness's response from he seemed more focused on getting home. From that point on, we'd be okay with striking that from the record.
Okay, in that case, sustained.
So, Ms. Parks, what about the second time that Jimmie Tanks came in?
Well, the second time would be several weeks later. July 1st. She came in after we were closed.
And did she buy anything?
Oh, yes, actually. A pack of peppermint gum. She was really looking for gasoline, and I told her about a shop I knew in Little Hamlet. She thanked me and rushed out.
And around what time did she leave?
Around 10:40.
I want to clarify something. How long does a typical drive from Little Hamlet to Willow take?
Around 3 hours. Not a drive I'd recommend. I'd probably need 5 expressos to get through that.
Your Honor, at this time, the defense is now screen sharing Exhibit 9. Ms. Parks, do you recognize this exhibit?
Oh, yeah. It's a map of Little Hamlet and Willow.
Does it look fair and accurate?
Oh, yes, it does.
The defense moves Exhibit 9 into evidence.
Any objection?
No objections, Your Honor.
It's entered.
So if Miss Tanks really did go all the way back to Little Hamlet, what was the trip she must have taken?
Oh, well, if you see on screen, she would have to drive all the way to Little Hamlet, where Hamlet Hardware is. Then she would have to make the return trip and drive all the way to Darrow's house. Now, that might not seem too long on the map, but there was an accident that day. I had to take it to tour myself on the way home.
Your Honor, stating for the record, the defense is now screen sharing a demonstrative.
I believe that time has been called in the chat.
Yes,
Your Honor,
that's our understanding as well.
Your Honor, if we can get one last question through. Without
there's a very slight time discrepancy, so one last question.
Well, I believe that the defense is also entitled to 15 seconds of grace time. So that's completely all right with the prosecution.
All right, keep it brief.
Yes, Your Honor. Co-counsel, we can get that taken down. If Miss Tanks left at 10:40, around what time would she have returned at home?
I'd say she'd return at around 3:20 a.m.
And what time was the fire?
Midnight. My heart and coffee, Albert's birthday.
Objection as to lack of foundation, Your Honor, may I be heard?
Yes.
Your Honor, there has been no foundation laid that this witness knew the fire took place at midnight on July 1st, 2024.
Response?
Defense?
Yes, Your Honor. It's common knowledge, since we're sitting in a trial today about Bertie Darrow's burnt home, that it happened on July 1st and it happened at around midnight. Your Honor, the witness saw it on the news and she's able to testify about this.
Pursuant to
Your
Rule
Honor.
603, or no, not Rule 603, sorry, Rule
615,
615, this witness has been constructively sequestered and has not been present throughout today's trial. You are free to ask whether or not this witness knows this, but this witness has not been present and I don't believe knows anything that's taken place during this trial. So
Yes, Your
please lay that foundation. Sustained.
Honor. Ms. Parks, how'd you know what time was the fire?
I saw it on the news and everything. What?
Thank you, Ms. Parks. Nothing further, Your Honor.
Thank you. Cross-examination whenever you're ready.
Yes, Your Honor. Hello, ma'am.
Hello.
Let me just make sure I got this right. You've never been in court before, right?
Oh, I've never. It's my first time. So exciting, really.
Well, welcome. Just to let you know that cross-examination works, but I'll ask you a few questions and you'll answer with a yes or no. Got it?
Oh, I got it.
Okay, ma'am. So let's set the scene and see if the defendant was acting frantic the night of the crime. Because like you just said with Miss Lau, that the defendant came into your store, right?
He did. Yeah, Jimmie did.
But ma'am, you never mentioned that she looked distressed.
Yes, Jimmie did look distressed.
Ma'am, she was breathing heavy.
That is what I observed. I can't say for certain she was, but that's what I observed at the time.
She had a sort of funny look in her eye.
That's what I saw. I mean, it was night, so I can't be 100% certain again.
Ma'am, you were in your store with the lights on when you saw the defendant looking nervous, right?
She looked nervous to me, yes.
Ma'am, she kept pacing back and forth down the aisles.
That she did.
And ma'am, when she was breathing heavy, pacing back and forth while she said something.
I'm sorry, could you repeat your question? I did not hear that. I'm so sorry.
No worries, ma'am. So, when you saw the defendant pacing back and forth through the aisles, breathing heavy, she said something, didn't she?
I heard her distinctly murmur something, yes.
That something was there's no more time.
Yes, I heard her say something along those lines, but again, I can't be certain.
Ma'am, she said there was no more time. I need to hurry. Isn't that right?
Yes, that's what I heard.
All right, ma'am. And she also told you she needed gasoline.
Yes, she did.
And like you said, you have car parts, you have a bunch of hardware, you have gasoline at your store, surely, right?
We do have gasoline, yes, but that particular day we were sold out.
Like you just said, you were sold out, so you couldn't give her any gasoline, could you?
I could not sell her any gasoline, yes.
And when you couldn't give the defendant gasoline, well, you gave her instructions, right?
I did give her instructions on a map so she could go to Hamlet Hardware to get gasoline.
Exactly. And before she left to go to Little Hamlet, she said some words, right?
She did say some words.
Ma'am, let's make this clear. She didn't say, I love coffee, like you might say. She said, only some things are meant to burn.
That's what I heard her mutter under her breath, yes.
And after she said, only some things are meant to burn, well, you claim she drove to Little Hamlet, right?
Well, I mean, I can't exactly claim she drove to Little Hamlet. I really don't know if she made that trip. I actually don't know, because then again, I wasn't with her when she made the trip. I just thought she might go to Little Hamlet to get the gasoline she really needed.
All right, ma'am. Well, let's see whether or not the defendant had the opportunity to get fuel for that fire. Isn't it true that after she left, you remembered you had some gasoline in a shed behind the store, right?
Yes, we do. We keep it.
So that night, you went out your store, you went to the shed, and you looked for the gasoline.
I did. Yes.
And you recalled, like, you genuinely thought there was gasoline in that shed, right?
I remembered as there being gasoline in the shed, but my boss, Mr. Mason, he could have moved it.
Well, ma'am, that wasn't my question. My question was, you recalled having a tank of gasoline in there, right?
Yes, but I recall that we might have it. We usually keep it there for the store's generator in case of power outages.
All right, so it's usual to have gasoline in that shed, right?
I would say it is, yes.
But you don't know where the gasoline went, do you?
Mr. Mason, I have a foggy idea that Mr. Mason might have taken.
Ma'am, you haven't confirmed with your boss, Mr. Mason, that he took the tank of gasoline, right?
No, I am not. It is his store, though, so I'm afraid I really don't have no say.
So that's a yes to my question. You hadn't confirmed with your boss that she took the tank of gasoline.
Oh, yes.
And really, ma'am, for all that you know, the defendant could have taken that tank of gasoline, couldn't she?
Well, here's the thing. I would say no, because I really don't know if Jimmie knew that we even had gasoline in the generator. Jimmie doesn't work at my store. I don't know if she would know.
All right, ma'am. So like I said in the beginning of this cross-examination, you can answer my questions with a yes or a no. Respectfully, you could save that explanation for Miss Lau in a few moments, okay?
Yes.
So redirecting you back to my question, you don't know if Miss Tanks took that tank of gasoline.
No, I do not know.
All right, well, let's see if there's something else you can't be sure of. Because, ma'am, you claim you saw the defendant driving towards a city called Little Hamlet, right?
Yes. Well, no, because I did not see Jimmie's car heading towards Little Hamlet earlier. But
Exactly.
yes, I saw a car drive by heading towards Yellow. Well,
You think it looked like Jimmie Tanks' car, don't you?
yes, because Jimmie drives the average car.
Ma'am, it's your sworn testimony here in court that Jimmie Tanks drives an average car?
I mean, I see a lot of cars, so I'm not really sure it was Jimmie's.
Exactly, ma'am. You can't be sure it was Jimmie Tanks because not only does Jimmie Tanks drive an average car, it was dark outside.
I cannot be sure it was Jimmie Tanks. I really cannot.
Ma'am, that wasn't my question, respectfully. My question was, it was dark outside. Yes or no?
It was.
Ma'am, you were so tired. You needed coffee to drive, right?
I did.
5 shots of espresso.
Let's not talk about this in front of young children.
Well, ma'am, it's true we can talk about this in front of young children while you were tired, right?
I was.
You were distracted.
I was. There were fireworks.
Ma'am, you were like a small child looking at the fireworks, right?
I suppose you could say that.
Ma'am, you would say. You even stopped at the side of the road to watch them.
Yes, I did. Fireworks are entertaining.
Ma'am, fireworks are entertaining. So in other words, you weren't looking at that car you claim was Jimmie Tanks, yes or no?
Well, I wasn't sure I wasn't really looking at it really hard. I just saw it pass by. So I would say yes. I wasn't really looking at it.
Objection, Your Honor. 403 misleading. May I explain?
Sure.
Your Honor, first of all, opposing counsel's previous questions about when Miss Parks saw someone who seemed almost like Jimmie Tanks' car pass, that was at a completely different time than when she was watching the fireworks. So the last question that you were watching the fireworks so you didn't see the car pass is clearly misleading considering they didn't happen at the same time.
Your Honor, may I be heard?
Please.
Your Honor, that'd be something great for the witness to say. Miss Parks didn't say, oh, I wasn't watching the fireworks when I saw their car drive by, but respectfully, the bar for 403 is substantially more misleading than it is probative. Certainly, there's probative value here to prove whether or not this witness was paying attention.
What exactly was this witness paying attention to?
Whether or not she was looking at that car she claimed was Jimmie Tanks.
Okay, defense, do you have a response?
Yes, Your Honor. Testing the witness on cross-examination is not necessarily a form of probative value that moves forward their case theory. Your Honor, these two events happened completely at different times. The car that Miss Parks might have saw that was Jimmie Tanks passed like minutes before while she was still at the shop. And then it was only after she was on the road she stopped to see the fireworks. These are on 2 completely different timelines, and it can be misleading to the members of the jury.
Final response, prosecution?
Yes, Your Honor. To respond to Ms. Lau's last point of argument, Your Honor, credibility of a witness's testimony is most certainly probative. It is always probative to see if this witness testimony is credible. Your Honor, the witness can say, I wasn't watching the fireworks when this happened if there was a time discrepancy, but Your Honor, certainly it doesn't meet that 403 bar.
I would agree that this doesn't exactly meet 403. I don't think that this is substantially more prejudicial than it is probative. I think there's only a few moments between these two events taking place. It's still relatively in the same timeline. I will admit that I am a little bit lost on what's going on with this line of testimony. So, prosecution, I would encourage you to keep this line of questioning concise and please move it along. I feel like we're getting a little bit into the weeds here, but I am going to overrule at this time.
Yes,
Your Honor. Well, let's see if that timing of the defendant traveling between those 2 cities checks out. Your Honor, let the record reflect that we're going to be screen sharing Exhibit 9. Ma'am, like I just said on direct examination, if you got in your car, it would usually take an hour for you to drive from your store to Willows County, right?
It would. Around an
And
hour.
and like you said, because there was an accident, it added around 30 minutes, right?
Yes.
Ma'am, let's just do the math here. If Jimmie Tanks traveled from your store to Willows County, it would be 1 hour and a half, right?
I would assume so.
Now, ma'am, if you take a look at Bertie Darrow's house that's on the map, isn't at the center of Willow, right?
It's not at the center of Willow.
Taking a closer look at the bottom left corner of this exhibit, Bertie Darrow's house is closer to nuts and bolts than the center of Willow.
I would say it is.
And the center of Willow is what would take an hour and a half to get to, right?
I would say yes.
Ma'am, that's a yes to my question, right?
Yes.
All right. So let's say if you drove from your store, Nuts and Bolts, to Bertie Darrow's house, it would be an hour, right?
I've never been to Bertie Darrow's house, but perhaps I would say.
Objection, Your Honor. That's a lack of personal knowledge.
Your Honor, may I be heard?
Response.
Yes, Your Honor. As of right now, I'm not asking whether or not this witness has ever been at Bertie Darrow's house. I'm asking her to look at the map she's already previously stated she's familiar with, and it's specifically marked Bertie Darrow's house for this witness to say how long it would take from her store to Bertie Darrow's house.
Okay, just very briefly, this exhibit has already been entered into evidence, yes?
Yes, Your Honor, during the direct examination.
Are you using this for purposes of a demonstrative?
Yes, Your Honor.
Okay. Defense, do you have a response on those grounds?
Yes, Your Honor. It still requires Miss Parks here to have some level of personal knowledge of where Bertie Darrow lives in relationship. Because, Your Honor, this map isn't drawn to scale. While they may have lines there, they haven't measured the length of the lines to the centimeter to show that the center of town is farther than Bertie Darrow's home. Your Honor, it does take personal knowledge of this witness to be able to tell us exactly it is less than an hour 30.
I agree. I think that this map is clearly not drawn to scale. I think that general familiarity with a map is different than knowing exactly how long it takes to go from one place to another. I'm going to sustain the objection with regards to that specific question. I think you can still feel free to use this exhibit or this demonstrative, but asking the witness specifically whether or not it takes more or less time to go from different places on the map requires at the very least more foundation or some personal knowledge. So I will sustain the objection.
Yes, Your Honor. Now, ma'am, bringing you back to my question, you can't be 100% sure where the defendant left after she left your store, right?
I cannot be 100% sure. No.
Thank you, ma'am. I'll let you get back to your store. Your Honor, no further questions.
Oh, before you go, Miss Lawyer, thank you so much for being so nice. I heard a lot of bad things about lawyers. Would you like to take this 75% off coupon for a ladder? Would you please? I get a bonus if you buy.
Oh, thank you, ma'am, for that offer, but I have a lot of ladders at home. I hope you have a good day.
Yeah, you too. Thank you.
Thank you. I believe there's no time left for redirect.
That's right, Your Honor.
All right, this witness may be excused.
With that, the defense rests its case in chief.
All right. With resting of defense case in chief, I believe we should still have time for a 5-minute recess before our closing arguments. So everybody be back here at about 1:37 Pacific Standard Time.
Yes, Your
All right, everybody should be back in the room. If both sides are here and ready to proceed, then we're going to go ahead with closing statements. Prosecution, are you ready to proceed?
Yes, Your Honor, we're ready to go.
Defense?
Yes, Your Honor.
All right. Prosecution, you may begin your opening statement whenever you're ready. I'll ask everybody besides the closer to please turn off your video for purposes of the recording.
The defendant's fury fueled the Now, if there's one thing to remember from this trial, it's when Billy Huxley told you the defendant's words. I'll show Bertie Darrow what true fire looks like. Folks, that's not a coincidence. That's premeditated murder. Because the truth is that on that night, the defendant took gasoline in one hand and a lighter in the other. And today we've shown you all the evidence. We've shown you that Jimmie Tanks was sent to jail, had their life ruined, and it's reasonable that she was just pushed way too far. And that's exactly why we brought this charge of arson and attempted first-degree murder against the defendant. And of course, we can't just say that. We came into this courtroom with a burden, and we proved that today. Because the only reasonable explanation of the facts is that Jimmie Tanks' fury fueled the fire. And we showed you that today through two simple facts: the fury and the fuel. First, the fury. Folks, this fire didn't happen in a vacuum. It was born from years of resentment. Because today, Billy Huxley, a jail guard from the defendant's time in jail, told you that the defendant never let go of that grudge. Because the defense can refute the defendant's words all they want, but what they can't deny is the fury. They can't deny when we showed you the defendant's drawing of the exact same house on fire with the exact same date of the crime. Members of the jury, that's absurd. That's not what you call a coincidence. And second, the fuel. Today, Fire Marshal Dr. Harley Blaze showed you clear evidence that gasoline had been deliberately poured around the house. He told you that he saw Jimmie Tanks holding 2 containers filled with gasoline at the time of his arrest. Members of the jury, that's the smoking gun. Tanks didn't just have the motive and the fuel. She used them to set this fire. Because the defense is going to try to paint you a pretty picture. We're going to show you those images and ask some questions. But members of the jury, we know none of that was true. Because in cross-examination of Dr. Reynolds, we found out that she was paid thousands of dollars over her usual salary to make this report. We know how an insurance company works. They'll do anything to avoid paying out. Because this insurance company not only sent their expert to court today, but if Dr. Reynolds doesn't prove to you that this fire was accidental, they lose $1 million. Because members of the jury, if Bertie Darrow lived, Jimmie Tanks would never get the revenge on the one person that ruined her life. And so she was trying to avoid losing. Her fury fueled the fire. Now, members of the jury, I'm about to leave you. And Ms. Luo is going to come up here and try to convince you about how they won this case. But the truth in this case isn't about winning or losing. It's about Bertie Darrow, someone who got their life and their house burned by the defendant. Because you heard what Jimmie Tanks said. You saw the 2 gasoline containers that Tanks had in her hands during her arrest. Folks, you saw concrete evidence that Tanks is guilty. Because we have the real arsonist in court, right here. The defendant's fury fueled the fire. And you'll confirm that with your verdict. Find the defendant guilty. Thank you.
Thank you. Defense, you may proceed with your closing statement whenever you're ready.
Yes, Your Honor. She was framed with flame. Members of the jury, the prosecution has been telling the same story. But it doesn't matter how many times Miss Charlu says her fury fueled the fire, because the truth is Bertie Darrow's death fueled the flames. Think of a game of poker. The cards get dealt to the players and one person is given a bad hand. Cards that are near impossible to win. But she doesn't play the hand, she plays the players. She takes a risk and makes a big bluff. Goes all in with her chips and hopes the others will concede, and they do. And members of the jury, that poker player is Bertie Darrow. In her hand is a pile of debt, leaving her desperate for money. But she knows how the other players think. She makes her bluff when she sets her house on fire, risking everything. But instead of the police and the prosecution counsel thinking deeper about her hand, they're fooled. And that is why my client is sitting in this courtroom today. Members of the jury, my client was framed with flame. It is the prosecution and only the prosecution's burden today to prove beyond every reasonable doubt that Miss Tanks did it. They needed to prove every aspect of 2 counts, arson and attempted murder. It takes more than a few catchy phrases to meet the highest burden in our legal system. And the government hasn't been able to meet it once this entire trial because of 3 facts they just can't explain. The flame, the fraud, and the frame. First, the flame. You heard from Miss Parks when she took the stand today that Bertie Darrow bought a little bit of paint, 2 huge cans of paint thinner, and a fire extinguisher. Members of the jury, you don't need that much paint thinner for the little amount of paint Darrow bought. And you don't need a fire extinguisher unless you expect something to go wrong. It was Bertie Darrow who covered his home in paint thinner so it would all go up in flames with the smallest spark. Secondly, the fraud. Members of the jury, Darrow was drowning in debt. She had hundreds of thousands of dollars to pay back, and a teaching job just wouldn't cover it. She knew she needed insurance money, so she planned a fraud that'd be enough to cover every last penny of debt and give her new financial freedom. So finally, the frame. Bertie Darrow knew that a fire of this size would be investigated. So she pinned the blame on someone she knew the police would accept, my client. Bertie Darrow redirected the attention so she could walk away scot-free. My client was framed with flame. And earlier in today's trial, during opening statements, my co-counsel, Miss Vivian May, challenged you to find any piece of concrete evidence that links Miss Tanks to the scene of the crime. And throughout, members of the jury, you found none. You didn't hear any eyewitnesses take the stand today, putting Miss Tanks at the scene of the crime that night. There were no fingerprints, no forensic evidence. Even the expert they called, Dr. Harley Blaze, admitted he didn't find anything. The only thing that's keeping the government's case together is Bertie Darrow's word. And they're hoping you believe him too. But where is she in court today? Bertie Darrow has made all these claims and she doesn't bother to show up in court? That's because she's afraid. She knows her story has holes and she's worried about the consequences. And Miss Charlu kept talking about 2 points this entire trial. We'll walk through them one by one. First, as to the defendant's fury, Miss Charlu kept on talking about Miss Tanks' motive, but she forgot to mention Bertie Darrow's motive. Because it's Bertie Darrow who has the potential gains of nearly $1 million. While Miss Tanks just got out of jail, she was trying to rebuild her life, not destroy it forever. And they also talked about how my client planned the fire through the drawing my client. Members of the jury, it doesn't say on the picture, burn down Bertie Darrow's home. It's nothing like that. Instead, it's therapy. My client drew the picture in therapy class so she could learn to let go of her grudges. But that doesn't make her a criminal. A second, the fuel. Miss Charlu talked about how my client had access to gasoline that night. But members of the jury, if having gasoline a few days before the 4th of July means you're guilty, you better be ready to lock up everyone in that town. And Miss Reynolds testified today. She's here on her own behalf and agreed the fire was arson, but she also found paint thinner. Paint thinner in areas Dr. Blaze didn't test, and the person with access to paint thinner? Well, you heard from Miss Parks today. That was Bertie Darrow. Members of the jury, it was Bertie Darrow who covered her home in paint thinner. She's the one in nearly $1 million of debt, and burning it all down was the only solution. Members of the jury, look at the facts and come to the only fair decision. Find Jimmie Tanks not guilty. Thank you.
Thank you. Prosecution, you may begin your rebuttal whenever you're ready.
The defense wants to talk about poker? Well, let's talk about this. Jimmie Tanks wasn't dealt a good hand of cards. She was given the world before it was taken away from her. Because Miss Luo told you about a typical poker player. But here's the other one. The one that loses everything and tries to desperately gamble it back. So Jimmie takes a gamble for revenge. Because Jimmie Tanks lost everything. Her fury fueled the fire. Because like this, they said, the defense challenged us to find a single piece of concrete evidence that ties Miss Tanks to the scene of the crime. And we don't have a camera or fingerprints, but we don't need to. Because what we do have is supplies for setting a house on fire. We have an actual witness account of the defendant holding 2 containers filled with gasoline. Members of the jury, I want to take you back to the most important part of this trial. That drawing of the house on fire that you saw isn't a coincidence. The fact that the defendant drew a picture of that crime today with the exact same date is the most damning evidence we've seen today. Because reasonable doubt doesn't mean the most dramatic story. It doesn't mean it's the most flashy one that sounds like it came out of the murder mystery movie. It's the most reasonable one. And what's reasonable is that the defendant's fury fueled the fire. Find her guilty. Thank you.
What an amazing round of mock trial. What a great demonstration round for newbies to see. Both teams should be incredibly proud. We're going to kick it to all of the judges in turn. I'm going to have our presider dictate which judge speaks when. He will speak last. They're each going to say one big thing they really like coming from the prosecution, one big thing they really like coming from the defense. Then we'll announce MVPs. Then we announce which team is advancing to the final. Judge Rorta, floor is yours. Please take it away.
All right. I'm just going to go down the little list that I have by whatever order it is in the chat. So Andrew Thompson, I'll have you go first.
Awesome. So I would say the big thing, just kind of big picture that I really like the witnesses did is every witness had something that was super identifying about them, that made them stand out from the other witnesses. It's a thing that, other witnesses struggle with, especially as like in AMTA, where a lot of the judges are familiar with 6 witnesses, they can really blend together. So that was great. Attorneys, I would say the best thing the attorneys did was they were very confident and relaxed, even when it was clear they were dealing with something they hadn't planned with. So it's easy to be relaxed and confident when everything goes your way, but even when things were kind of unexpected, they were very confident and kept their composure.
All right, just going down the list. Jay.
Yeah, hi guys. I agree with everything said. Previously, this was an amazing witness round. I played that usually, so great. My big thing I really enjoyed from plaintiff was you focused on a couple pieces of evidence and centered your whole case around that. That's just great. For the defense, I really like the theory of the insurance fraud. That's always good as an angle. It's similar to my first case. But yeah, good job on it.
Margaret, if you have anything to add.
Yeah, I'll talk a little bit about the attorneys. I will say I have the same comments for both defense and prosecution. Honestly, the objections were like I loved hearing them. They were very well argued. They were very entertaining. And like my biggest thing about attorneys is when they don't move, and everyone was moving, everyone had good tone shifts. Everything like really flowed together, and I loved hearing your directs and closings, and it was just all very well done.
Stella?
Yeah, I'm gonna concur what everybody else said. I thought it was a really great round. I think some really big things was the characterization of all of our witnesses was really strong. We didn't have a single witness that let the energy lull, which I thought was great. Our attorneys were were very responsive, excuse me, and very prepared. I really liked from the defense, you guys actually chose to focus on a lot of the things that the other side didn't know, which I think is a great choice, especially when you're dealing with a high burden like this. I think that's a fantastic choice for you guys. And for our prosecution, I thought specifically the characterization that you guys chose, as well as the range between your two witnesses and the portrayal with the attorneys and those two witnesses was really, really strong and showed a very diverse viewpoint, even within those two witnesses. So I thought everybody's presentation was really strong.
All right, William?
Yeah, I agree with everything other people have said. I just want to mention like one specific examination where I think my favorite moments from both the prosecution and defense are. That's the examination of that's the cross-examination of Jordan Parks. I think for the prosecution, the crossing attorney did a fantastic job in just working with the witness and matching the witness's very nice energy, just appearing cooperative. I'm just here to ask the questions, get the facts straight, and then at the end, I have many ladders, but thank you for the voucher, that kind of things. It's a great way to approach a cross-examination, just to match the character's energy, and because they have a great character, so it's a great strategy to just use that to your advantage. And then the character itself is so well performed. I love how Ms. Parks was drinking coffee on camera, even when the attorneys were arguing objections. That kind of consistency, that kind of attempt to carry the character throughout, I think that's a great example of how to act a character.
All right, I'll end off this little bit of judge comments. I've got, unfortunately, most of the things that I have were for both sides, that I thought both sides did a lot of the same things well and some of the same things poorly. But there was one thing from the prosecution. I thought you all did an amazing job of working with exhibits and working with demonstratives. There's really something to be said about giving the judges and the jury something physical to lay their eyes on. Even if you're just reading out what's on it, even if you're just using the demonstrative for those same purposes, putting something in front of me that I can really like see instead of just you talking is very, very influential. I thought that the defense did a very good job of not necessarily using that, but going towards the motive of Darrow. When that moment happened where it was like talking about the insurance and how like the company might have to pay $1 million, and then instantly turned around to Darrow might gain $1 million. That was like that switch. I was like, okay, all of a sudden the bias about the insurance wasn't as poignant, and all of a sudden Darrow has all this motive to do this. And that was a very clear moment in my mind. So that sort of like kind of using like a theme flip in order to turn the motive to the other side was very well done. But that's all I have for right now. I thought you all did an amazing job. This was like, I think that my fellow judges would agree with me that this is I would call this a college level round. Like this is both teams. I would have expected to see all of you in tournaments that I'm going to.
To inspire some of the folks who might be watching right now, can any seniors who are competing in this round raise their hand? Any juniors? Any sophomores? Any freshmen? Do we have an 8th grader? Let's talk about the MVPs. Then let's talk about the results. First, on the attorney MVPs, there were 6 judges. All 4 advocates got at least 1 vote. There is an unbreakable tie for the MVP of the round. These individuals both got 2 votes. Let's acknowledge from the prosecution, Miss Sailee Charlu, from the defense, Miss Anya Luo. As far as the witnesses, turns out that every witness got at least 1 vote. And there's an unbreakable tie because 2 witnesses got 2 votes. Co-MVPs from the prosecution, Miss Audrey Ma, and the defense, Miss Mira Jang. That takes us to the totals. As I was watching this round back with my wife, who's also a mock trial judge and coach, she said, "This is really close. I don't think I could call it." And I said, wouldn't it be funny if with 6 judges, there was a 3-3 split or something like that? So the first 2 ballots came in, +4 and +9 for the prosecution. The next 2 ballots came in, +4 and +10 for the defense. The next ballot came in. It was a tie. The final ballot was a 1-point margin. Congrats to everyone in this round. Truly phenomenal work. But advancing to the final by a single judge, single point, Team Gold, the prosecution. I'll stop the recording now. Congratulations to all. What a great learning resource.